and welcome to Legally Speaking with me, Tarun Nangia. Today we embark on a long series where we'll be discussing the Mediation for Nation scheme that has been launched by Justice Suryakant. It is underway, and we have to highlight 30,000 mediators are working, 1.69 crore cases have been identified, and this whole scheme is going to be audited by the Bhopal Judicial Academy to show what work has been done on ground. This is a very refreshing thought because, uh, you know, uh, Justice Suryakant, who's also heading NALSA, goes on to show that we are going to show you what we have done, not just announce a scheme and say that it's working. It's really refreshing to hear this. And in a country where the pendency has crossed about 6.5 crores, this is something that we all wanted, and Justice Suryakant has given it to us. I would like to, in a sense, thank my panelists today who've spared time from their busy schedule. I want to welcome Justice Arjun Kumar Sikri. As we all know, sir is one of India's leading arbitrators. He is a sitting judge of the Singapore International Commercial Court. He has served as a judge of the Supreme Court. He has served as the Chief Justice of Punjab Haryana High Court and the Delhi High Court. And also, may I would mention, when I started the show, one of the first shows was with Justice Sikri on the topic of mediation. And also, one of the discussions with Justice Suryakant was at the Chandigarh Judicial Academy. That too was on mediation at the Global Pound Conference. So life comes full circle. Little did we know that Justice Suryakant would go on to become the Chief Justice of India. And Justice Sikri, as we all know, is one of India's leading arbitrators. We will also want to welcome Dr. Abhishek Manu Singhvi. As we all know, he's a fourth-time sitting member of Parliament. He is also a member of the apex body of the Congress, which is the Congress Working Committee. He has also chaired the Standing Committee on Home Affairs in Parliament, one of India's leading lawyers, and also a top voice who's followed globally. Thank you so much for your time and looking forward to your insights on this issue. We have with us Ryan Karanjawala, who's managing partner of one of India's leading litigating law firms situated at the city of New Delhi. His firm has been part of many important disputes. The highest one was the Tata Mystery Battle, where he was for Ratan Tata and Tata's. One of the recent one was for Aryan Khan, which is son of Shah Rukh Khan, where his firm appeared for Shah Rukh Khan's son. Good to see you, Mr. Karanjawala, and thank you for your time. At the outset, I want to request Justice Sikri, in his opening comment, to address the vision and mission of Justice Suryakant that he has embarked upon to reduce pendency via mediation for nation. Over to you, sir.
I think it's very timely, and if I can use that phrase, yes, mediation is one whose time has come. It's an idea whose time has come, and here it has to be implemented in full measure. And coming from Justice Suryakant at this juncture, when he's going to be the Chief Justice of India after 2 months, shows that what is in his mind, even when he's going to become Chief Justice, when it comes to judicial reforms. Let me say, insofar as mediation and mediation's importance is concerned, and it's, I think, very aptly and rightly chosen by Justice Suryakant, as I said, as a part of, I may say, judicial reforms. There are large pendency of cases today. And the problem of huge areas had always been there, but it has worsened during COVID and post-COVID. Unfortunately, if I may say so, that the number of cases rose during COVID, which was inevitable because courts were not functioning in full measure, even when there were online hearings, etc., which even now continue in some respect. But then, even after that, we have not been able to contain the delay, the number of cases which are in the system. That means the cases which are filed are much more than the cases which the judiciary is able to dispose of. And be it subordinate judiciary at district court level, be it high courts or even the Supreme Court, because even in Supreme Court numbers are going up. And so it's almost, I think, 80,000 in Supreme Court today. And the total number of cases in the country has almost touched 50 million, or maybe has crossed 50 million of figure, and which was about 30 million at the time when the COVID started. And so therefore, we have to find out the ways how to reduce the areas. Our judges are trying to do their best. They are really, the workload as far as Indian judges is concerned is tremendous. It is humongous. And when we compare it to the workload of other countries, the number of cases they are disposing are also very good. But still, in spite of all these reasons, we are finding these problems. So therefore, there are some issues with the in the manner and in the system where these cases are decided. There may be many ways to tackle with this, but mediation is one of the finest ways, if I may say so. And since we are today discussing mediation, I will not go to other issues, etc. In 2002, Section 89 was inserted in our Code of Civil Procedure, and mediation was introduced, apart from other forms of settlements, etc. So, mediation, arbitration, lok adalats, and also mediation was also introduced. And uh, so, that was the, if I may call it, the first phase, statutory introduction of mediation. And Section 89 talks of court annex mediation. That means the cases which are pending in the courts can refer those cases to for mediation to be settled through mediation. So in the first phase, what we needed was that Section 89 has come, that now, but there was no ecosystem as far as mediation is concerned in this country. So we had to first establish that. And I always say that I am thankful to Salem Bar Association, which filed a writ petition challenging the validity of Section 89, virus of Section 89. Not that, so the lawyers at that time were against mediation. So filing of that such a petition would not be a welcome step. But why I'm saying is saying so that I am thankful to them. The challenge was rejected. But in our country, many laws are passed which remain on paper, are not implemented. But here, when it was brought to the notice of the Supreme Court, and when the bench at that time considered the validity of this provision, they did not stop there by rejecting the petition only. The judiciary took it on itself that, okay, now we'll see that mediation takes off also. So therefore, the committee was constituted, first headed by Justice Jagannath Rao, who was the chairman of the Law Commission, that you formulate the rules on mediation. And a committee was constituted in the Supreme Court called, which is existing even today, MCPC, Mediation and Conciliation Project Committee, and to oversee the mediation, I mean, how it takes root and how it progresses. And rules were framed. Then the court did not stop there also, because when they were presented those rules, model rules as we call it, and then the directions were given to all the high courts by the Supreme Court, all these in judicial orders, that you frame within 1 month the rules in your respective high courts, depending, going by these model orders, and suitably amending it or modifying it, keeping in view your local requirements. So this is how it started. And I remember then the MCPC or the Supreme Court even started one pilot project. Pilot project was the 30,000 courts was taken, and this I mean, as the pilot project, where some trainers had come from America to train the mediators, to train, and initially it was judges of district courts who were chosen, picked up, that they would be trained, because we didn't have. Now, in order to function, you need the manpower. That means the domain expertise of that you need mediators, you need advocates who are able to present the cases, you need infrastructure and all these things. So the Supreme Court took that, and that this training was given by those the mediators or trainers from America to the judicial officers, And in 2005 or 6, I think it was 5 or 6, when this mediation center was to be inaugurated, Chief Justice of India came, but then the lawyers had protested. I still remember they even ransacked the mediation room. But anyway, that's history now. And so therefore, I always say this was the first phase. During this, in next few years, this with the help of the government also, in government of the day, which very liberally gave finances and to all legal services authority, that legal services authorities are there at state national level. It is in NALSA, but then the state legal services authority, that is in the every high court, and then their district legal services authority. All they have their offices. That you will have now this mediation center there. So with the help of that money which was given, these centers were also established. This is how many hundred centers, maybe I don't know, 700-800 centers could be established throughout the country. And the mediators got training, etc. So I need not go into
Yes.
detail into that. So
Yes.
first phase was that. Now,
Okay.
second phase, I always say, was that now we have to popularize it. We have
Yes.
to ensure that the matters are referred for mediation. So
Yes.
training was given to the judges for this is referral training.
Yes.
That is the judge with whom the matter is, whether it is ripe for mediation, whether it is the right stage that I refer to mediation, while referring it to the mediation, what kind of order should be passed, all that, those things. And I
Point.
remember in the High Court, sorry, when I was acting Chief Justice, we gave training to all the 700 district judges, etc. But that was the second stage, and that now it picked up, and now we are on the third. So in the second stage, I would say that yes, in the meantime, legislation has been passed. In
Yes.
2023, the act has come, and
Yes.
we have infrastructure. Also, we have many mediators as well who
Point.
are there in place. So I say that this is now the third stage.
Third stage.
Which now Justice Suryakant is going to start.
Thank
And
you.
we have to then come out with the, I mean, in all force, we have to start it. And in what steps it should be taken and how it should be done. If you want, I'll say it later. But
Yes.
here I would only say that it is now to become a full-fledged profession, that those persons who are practicing they should practice in as many, at least has happened in Europe, it has happened in America. We have trained mediators who have their offices. Pre-litigation mediation needs to be done, and I'll say at two levels we have to tackle again. First is
Point.
the cases which are already pending, section 89. The judges should now start sending those cases in full measure. You have said 1.69 crores cases are already identified,
Yes.
and so therefore that should be done. And
Point.
secondly, we have to now, so that the cases don't come into the system.
Point very well taken. But the key takeaway from your introductory answer is mediation as a full-time profession. Cases identified, they have to be referred. There have to be pre-litigation mediation in full force. The three key takeaways that we see. Now we will go to
What steps should be taken in detail? I'll allude to that later. Okay.
yes. We'll go to Dr. Abhishek Manu Singhvi for his opening comment on the vision and mission of Justice Suryakant, and he has enough and more time now. To this is the first campaign, maybe more to come. Over to you.
Tarun and my esteemed panelists, let me start by saying and welcoming a very good initiative, in particular because it has as its pusher and backer. Remember, in all these things, you need one sutradhar, a very pragmatic judge, a judge who is obviously on the cusp of becoming a Chief Justice. And therefore, that direction and momentum will ensure its success, is what we all hope. Everybody has good intentions, but then you need to have that direction and momentum. And he's right absolutely in saying that ultimately the operational success must be measured in numbers, efficiency terms, audits. A lot of times we speak from the pulpit, but do not have a post-implementation audit, which is what he has promised, and that makes all the difference. Let me go down memory street, and I'm very proud of this, that I have a bit of a stake in this. Way back in the mid-90s, Chief Justice Ahmadi constituted a Indo-US American group. And I was privileged to be part of that. very young lawyer then, not too old even now. I don't consider that then really young in those days. Me, two more senior advocates and judges of the Supreme Court, along with US Court of Appeal judges, the number 2 rung, and a few American lawyers. And we studied the Californian system. Some of us don't know that the beginning of ADR in the most successful model globally was California. And we studied in the mid 90s at San Francisco and elsewhere this model. And it was our report, which towards the end of the 90s, and after some politics, which I don't have time to discuss now, was enacted as Section 89. Now, in our original report, we actually gave a menu card of alternatives. And one of them is actually statistically the highest success rate in California. That is mediation by a sitting judge who is not the trial judge. And strangely, even in a country like US and California, where the culture is much more pro-mediation, they found statistically that the maximum success rate was for mediations done by a sitting judge, which they called by name judicial settlement. We discussed that in the report, and I have a paragraph there which I was proud to author, saying that we'd love to have it in India, but not in a country where at all times since independence, 1/3 of High Court judges have had vacant seats. 1/4 of all trial court judges have had vacant seats. So we wish we could have had that, because that would have ensured a greater statistical success. Point number 2, that while we are talking, sermonizing, lecturing, I just gave a lecture on the reforms in the administration of justice at SRM University 2 weekends ago with the former Chief Justice of India. I said, under our very noses, arrears have actually come close to 6 crores. Justice Sikri was very sympathetic and polite when he said 5.5, because we don't count the tribunals, which are usually pending along with that. And we have to stop blaming COVID now. COVID is long gone. It is just a net increase. And the Supreme Court is always an island of many Indias in one. Supreme Court, I think, doesn't really matter. It's under control. I mean, I don't really care if it's 60, 70, 80, though it must be controlled. The real problem is in the lower 2 levels, especially the trial courts, which have 80, 85% of these 6 crores. So that the need for it is imperative, and we are not discussing that today. We're discussing mediation. So, but the reason has to be that to unclog the arteries and take it out of the system into another set of arteries, which hopefully will not get clogged. In our menu card, minus judicial settlement, the only statistical success has been Lok Adalats, which is why Justice Suryakant's initiative is particularly laudatory, because he's now trying to make this a statistical success. Justice Sikri is absolutely right. He's traced 2 or 3 phases. But, the democracy tax we pay in this country means that it is hopefully not too little now, but certainly too late. It has taken 25 years to reach Justice Sikri's analysis of 2.5, 3 phases. That's a bit too long for mediation to settle down here. When we studied this in California in the mid-90s, I personally went to a firm which is very famous, known JAMS, Judicial Arbitration and Mediation Services. These were common firms. The most famous was JAMS. In Europe, it was CEDR, which practiced only in ADR. We have only now started having such firms. Perhaps a person like Ryan can start a separate division of his firm, practicing only in ADR. No litigation, no corporate work, nothing, only ADR. Now, that has not happened in India. It's now hopefully will happen, because we have a brand new state-of-the-art 2023 new act, and that's really state-of-the-art. It has got all the new concepts: certification, assessment, mediation counsel, ethical conduct, discipline, etc. But we need to operationalize it. And we need for that to meet the Indian genius sometimes of spoiling that which is intended to be ideal. We need to, for example, have good people first and foremost. I mean, look at for example, Lok Adalats have had a 20 crore figure from 1995 to 2023. 20 crores. That is some achievement. But we all know the limitations of the category of cases they do. We do not have similar published figures for mediation in an aggregate sense. We must start monitoring it. We need to have good people who are efficient, focused, and not just mediators in name, or not merely by eminence. You need, as Justice Sikri knows better than anybody else, you need arbitrators who actually deal with the matter efficiently and deal with it. Not just merely, because you have a stamp behind it. And that is important also to select cases. There should be both on the pre-litigation mediation level and in the later mediation levels, some form of very efficient selection, because some matters are inherently not susceptible to mediation. And if we do that, you'll be putting the right crop for mediation. We have had some statistical experience, not very encouraging, with sections like 12A. 12A of the Commercial Courts Act is a very good step towards pre-litigation mediation. But what is happening in practice? Just now we are doing a major case in the Supreme Court, and there is Justice Padiwala's judgment a few months ago, very important. It has become in many cases a form. The error is to think that every litigant, and remember almost every plaintiff in India does that, files a strong Order 39 injunctive application, it automatically means that he has overridden the need for a 12A pre-litigation mediation. Now the judgments have come saying, no, that's not so. You can't just override it except in a very difficult or a very necessary case, which is imminent. But what is the practice in India? You make these nice provisions, but you have to consistently enforce them. Increasingly, we are having in commercial matters cases where this 12A is considered a formality. You file a strong Order 39 and you waive it and you straight away go to litigation. These things have to be curbed, and the consistency across courts, across district courts, where the numbers are the highest, across high courts. Supreme Court I still consider an island. That consistency has to be increased. We have to keep increasing the manpower of mediation, as Justice Suryakant in that statement has said. We need to make it a culture, which is now happening. I find a lot of my colleagues wanting to attend these certification courses and deal with that as practitioners. So I think though it is certainly too late, hopefully it is not too little now. It is very late. 25 years is a lot of time since Salem and all that. But we are hopeful because especially you have a Chief Justice who is pushing it, an incoming Chief Justice who is pushing it. And hopefully the length of his term will mean that this will be a war. It should be a mediation war across the country to make at least fractionally achieving those numbers which have been achieved by Lok Adalats in a different category of cases. The numbers matter.
Thank you for that opening comment and detailing what you think about Justice Suryakant's vision and mission with mediation for nation. I'll go to Mr. Ryan Karanjawala to opine on Justice Suryakant's vision and mission with this campaign titled Mediation for Nation.
So Justice Suryakant's mission is the need of the hour, especially because of the way the two eminent speakers before me have put the whole thing in perspective. You are faced with a legal situation today where the courts are undermanned because they do not function at full strength, where the docket is overburdened because it reaches several crore outstanding matters. Fortunately, today, the infrastructure to have a parallel ADR system, namely mediation, is slowly galvanized and come into place. Not yet in full format, but certainly getting there. This is the moment where Justice Suryakant, as Chief Justice of India, has to do for mediation what Justice Bhagwati did for the public interest litigation cause. Take up something, push it to its hilt. And the most important thing is that unless you do it and do it soon, you might soon find a system where people start losing faith in the judicial system because it starts collapsing. If a person knows that when he goes to court, he's going to take several years before he gets out of court, then he starts losing faith in the system. Here, you have the chance to offer him an alternate, which is a mediatory system, which can be manned by people outside the judicial system, lawyers, even people who are non-lawyers but trained in mediation, who can come forward and meet the need of the hour. As far as this mediation puzzle is concerned, I think there are still two pieces missing in the crossword puzzle, which can be utilized to benefit. One, time and sufficient detail must be given to see as to what benefit you can take out of AI, artificial intelligence. The whole purpose is today, when you go I mean, we've installed it in our office, and we find it makes a world of difference. You can plug in all the facts, and they will give you the alternate arguments on both sides, and so on. The AI, there should be an AI national grid which people can access, and the mediator can immediately come up with two or three alternates which AI throws up, which is the probability or the possibility of the case being decided A, so much percentage, B, so much percentage, C, so much percentage. And when he has his task cut out before him, after that, the mediator finds it much easier to drive the two people before him to a satisfactory solution. The second thing which I think needs to be installed and implemented is the concept of AC, which is the concept of actual costs. See, one of the reasons why people still take a chance on litigation is they feel that, look, let me litigate. At the most, what will happen is that the matter will go on for years. Ultimately, if I lose, I'll pay at the end of the year. But if the courts got into the system of awarding the actual costs of the winning side on the losing side, then there would be a much bigger incentive not to litigate and to try and see as to whether you can finish off the mediation. I'll give you a personalized example. There was this, Manu will remember him, there was this man called Dilip Doshi. He's a cricketer. He also used to run the whole Mont Blanc chain of stores and all. He was the Mont Blanc franchisee in India. He's a friend of mine. One day came to me, Mont Blanc had terminated his uh, uh, franchise and he wanted to litigate. But it was an international arbitration clause. I had my office study the papers. I looked at it and I said, look, you signed away your rights. Don't go to court. But he never listened. He said, no, no, there's a God above and I'll get justice. He went to a Swiss arbitration. Not only did he not succeed and pay his own lawyer's cost, but ultimately they mulched him with damages of paying the other side's cost of £3 million. He had one house in England which was taken away and he was virtually bankrupted. It is this stick of having to pay the other side's actual costs if you lose, that to a large extent can today act as a deterrent and push people to the process of mediation rather than actually go through with the whole litigation. I think that is also something that should be sort of thought through and dovetail into the proceedings of litigation in India.
Thank you for sharing that anecdote with the viewers. Made it interesting. Now we move to the round of closing comments. We will start with Justice Sikri, and this will be your message to Justice Suryakant and your closing comment, both in one answer. Over to you.
Yeah. No, first let me say, I mean, once you say my message to him, so I will first congratulate him. It's really a visionary step, and he should now go whole hog implementing it as everybody is saying. But some of the, ideas in my mind which occur to me, which should be, those measures should be adopted in trying to make it successful. You see, as you have informed, 1.69 crore matters are already identified for mediation. I presume, and obviously, these are the cases which are already pending in the court, correct? And therefore, they have been now identified. Now, these should be categorized also in different categories. How many are family matters, family disputes? How many are commercial disputes? How many are motor accident disputes? How many are property disputes? How many are, say, partnership disputes, etc., in different categories? And because then we have to have, yes, mediators, we need mediators to resolve this. You have again given a figure that there are 11,000 mediators and it is going to be mediation family of 31,000. So these 31,000, according to me, then he should try to pick up those mediators with their domain expertise, as Dr. Singhvi also mentioned, because there are some who are very good in resolving. I have seen in Delhi High Court also the mediators pool which is there. There are some who are very good in deciding family disputes. There are some who are very good in deciding commercial disputes, etc. So as I said, time has come now to make it a full-fledged profession. So in that sense, we also need those mediators like advocates, that these are the advocates who are good in this field, these are the good advocates in this field. As I always say, we need, even for deciding the cases also, particularly complex cases, judges also should have domain expertise. So here domain expertise is needed of the mediators.
Point very well.
And the next thing I would say that there should be training programs, not only, I mean, while there are training programs and all these mediators are certified, they have their training and then they get the advanced training also. But then I have seen some of the training programs in Western countries like US, which Dr. Singhvi alluded to, and I have seen in SIMC, Singapore International Mediation Center, and then they have one or two other centers also. Their training level is very, very high. I think we should try to imbibe those kinds of training programs and give that kind of training to them. And training is not only for mediators. Training is, as I'm saying, for advocates also who appear before these mediators. When I am appearing in the court, my I mean, as an advocate, and when I argue the case, then the manner in which I have to argue the case is totally different from when I appear before the mediator, and there the purpose is how to settle this case. So the different outlook and different kind of mindset is required, and there are training programs for advocates also that should be done. Then I would say that if it is chosen, not chosen, I don't know. Complex commercial matters which are pending in the courts, particularly at the High Court level, etc., they should also be chosen and given to those kinds of mediators who are very good in this. And of course, and at the end, I would only say that the training is needed. So this is in a way pre-audit. After what happens after that, we are doing an audit. Here we are doing an audit of for 1.69 crores. What is the infrastructure which is required, how mediators, how many advocates which are required. We have to have that system in place if we really want it to be successful. And NALSA, this National Judicial Academy is given for this audit. My advice would be to National Judicial Academy, I think they would take with you some students and teachers from law schools who are really good in it, because now Bar Council of India has already made mediation as a compulsory course. So therefore, but then they would be really able to help you, and teachers are particularly able to help you in conducting this kind of I mean audit, or they are expert in these things.
Point.
So these are some of the, and one thing more I would say at the end, along with this, ODR should also be taken. ODR should be made as a part of ADR or this mediation, and should also be utilized in full measure.
Point very well taken. Thank you for the closing comment. And there were whispers in the market that within 1 week's flat, you settled a 3,000 crore dispute via mediation recently. So if that much can be settled in a week, mediation has huge potential for commercial matters also. What fees mediators are paid is another matter of debate. I'll go to Dr. Abhishek Manu Singhvi for his closing comment and message for Justice Suryakant.
You're mute. Manu, you're mute.
Since we have to make closing comments in 2 or 3 minutes, let me first and foremost adopt all the other suggestions, because there's no point repeating them, and try and make some additional ones. So each of these are very important. My point, which I want to make in closing, is that Justice Suryakant, of course, has started a whole campaign, I would say, and that's very welcome. But we need to think of the longer term, and of course, the middle and the shorter term. So the shorter term and the middle term we've talked about, but you must really now think of the longer term to institutionalize a culture of mediation in this country. Now that means, this is a nice word, institutionalize a culture of mediation. It doesn't actually happen. It's a longer term view you have to take of it. How you institutionalize Lok Adalat culture. Now, number one for that, you have to increasingly make mediation / conciliation less of a stepchild. Today, it is a stepchild to the successful advocate. The successful advocate is the one who gets up like a gladiator and argues in court. You have to therefore develop a whole breed of advocates and non-advocates and they are given as much importance and as much recognition as successful practitioners. The arbitration bar has had relatively less recognition. It's now developing. It's called an arbitration bar than the litigating bar. But the mediation bar and the non-bar, that is the non-advocates, are a real stepchild. And that has to change. Number two, you must, there are practices in Indian which we as litigators find in actual practice. A lot of people are adopting mediation only to delay matters. So suppose you have, one side which comes to court always wants to delay. So another additional 3 months is given by offering mediation, knowing that one day before the end of mediation, you'll pull the rug from under the feet of the other side and say mediation has failed now let's start litigation. Those things have to be nipped in the bud in the beginning by a clever, focused judge. You must also, as is rightly been said, create disincentives inbuilt into the mediatory process. When you refer, you must make it clear that, coming back to the court will mean some kind of costs for the losing side, always real costs, which are the other side's costs. That must start at the process of referring to mediation.
One minute, sorry, I'm just interjecting, just to add to what you are saying. In England, judicial precedent and decisions were given in 2005, 6, etc. If you don't agree on mediation or it is found that you really did not cooperate, even if you ultimately succeed in litigation, you will not be paid cost.
Oh,
interesting example. Because the practice which I have seen developing is a lot of people opt for mediation saying क्या फर्क पड़ता है mediation के end के एक दिन पहले तो हम वापस litigation में आ सकते हैं. Let us waste time. It is adding some time to the litigation. That is not happening in such a big scale, but it does happen. And we have to nip it in the bud. Also, before I end, this taught course of mediation hasn't really taken off. It has only started recently. We haven't had a structured taught compulsory course in this till recently. Now, this should be taken in a big way. We have workshops of moot court. We should start workshops now of mediation with students, taking it seriously and ultimately choosing it as a ultimate mode of practice when they pass out of law schools.
Only to add, now many law schools are having mediation competitions also.
So this is what I mean by a culture of mediation. And lastly, again, beware of some practices. Let us not shift those cases which would be easily susceptible to Lok Adalat dispute resolution into the mediation category and increase our numbers. It was not said very clearly. I'm saying it more clearly. There are a large category of cases which are inherently susceptible to Lok Adalat. We all know the motor vehicle accident claims or the, some family disputes, etc. Let us not just shift it to the mediatory category and then exult and triumphantly proclaim that we have increased our numbers of mediation solutions because they were actually intended for the Lok Adalat. So that these are kind of things we must do. Of course, with all the other suggestions, I agree. And this will mean a whole cultural war on the whole concept of mediation as central, a centrality to it in dispute adjudication in our system.
Thank you so much. And since we saw Justice Suryakant pushing mediation while he was a judge in the Punjab Haryana High Court, I think this is a subject close to his heart. We will now have the closing comment as a last word for the day on the show. Mr. Ryan Karanjawala, over to you. Your message for Justice Suryakant and the end message of the show.
So to take a cue from what my earlier speaker said, the first thing that Justice Suryakant has to do is to try and ensure that the whole legal ecosystem, not just judges, not just lawyers, but even teachers, all those who have something to do with the practice of law, become mediation friendly. The second thing that he'll have to do, as Justice Sikri also pointed out, was initially you have to select cases which are the most susceptible for mediation and send those cases for mediation. Because initial success begets more success. If the initial years of mediation practice take off and people suddenly start finding that it is something that is actually working, then you will suddenly find a whole lot of people who earlier were disinterested taking far more interest in the whole process of mediation. It's a carefully constructed path that he'll have to walk. He'll have to shift and nuance himself over the period of time. But we wish him all the best in doing so. And in doing so, he will have a yeoman service for the whole country's litigation spectrum, so to speak.
Thank you. And with this, we come to end of the part 1 of our series titled Mediation for Nation, which is Justice Suryakant's, in a sense, vision and mission to reduce pendency in India. We can only understand how much pressure the Chief Justice and also the head of NALSA has in these issues. And Justice Suryakant has shown his willingness to take the pendency challenge head on, now as head of NALSA, and of course soon as the Chief Justice of India. I think this will continue, would not stop at September 30. Post the audit, this continues. We will get to then do a show again on this issue in a renewed form when this scheme is introduced. But I would like to thank Justice Arjun Kumar Sikri, Dr. Abhishek Manu Singhvi, Ryan Karanjawala, Managing Partner of law firm Karanjawala and Company. Thank you for joining us on this very, very special series of the vision and mission of Justice Suryakant titled Mediation for Nation. Thank you so very much.
Thank you.
Thank you.
For more such videos, subscribe to the Newsx YouTube channel, hit the bell icon.